Good evening, everyone. My name is Angela Zhang. I'm the director of the Center for Chinese Law at the University of Hong Kong. Today, I'm very honored to have a distinguished guest to join our international speaker series, Professor Katharina Pistor from Columbia Law School. She's a leading scholar and writes on corporate governance, money and finance, property rights, and comparative law and legal institutions. Professor Pistor is a very prolific scholar. She's the author or co-author of 9 books. And today she will bring with us her latest book, The Code of Capital, How the Law Creates Wealth and Inequality. I heard that this book has been translated into Chinese. And so you can probably get it from Hong Kong bookstores. And this book was named one of the best books of the year in 2019 by the Financial Times and Business Insider. So I can't wait to hear Professor Pistor's talk. And we have a discussion today. Our professor, Jack Kronke, is associate professor of law at the University of Hong Kong. He joined our faculty in 2018. He currently teaches property, equity, and trust, as well as courses in common law reasoning for civil law students. I really cannot think of a better colleague to comment on this book. So without further ado, let me leave the floor to Professor Pistor.
Well, good evening, everyone in Hong Kong. Good morning or good afternoon if people join us from other time zones. So it's a great pleasure for me to be here today and give you basically a run through the argument that I develop in the book. I won't be able to go into all the details, but I'm looking forward to your questions as well later on. So here's the core idea of the book. The book basically states that capital is coded in law. Capital, I mean, is a wealth generating assets. And by law, I mean the institutionalized means of coercion. There are, of course, many other definitions of capital abound. Economists would typically think that capital is one of the 2 factors of production, labor and capital. And this is not entirely wrong, but the point for me is that before you can put anything into the production process, you have to be able to control it and you have to have a right to it to be able to funnel it into production processes. So you must have a title, and that is a legal institution. Law is, of course, abstract. I'm trying to bring it down to a certain level that it makes things a little bit more easier, but I also know that many lawyers are in the audience. So here's what capital's attributes are. So I'm saying, if you want to give me a simple object, a promise or an idea, a piece of land or a promise to pay, or an idea for creating a COVID vaccine, for example, and you want to flip this into a wealth generating asset, you have to give these assets certain types of legal attributes. And here are 4, and you need typically 3 out of the 4. The first is that we rank in law the rights that different people have to certain assets. So it's priority that you need. You won't have stronger rights, others have weaker rights. If you have stronger rights, you win. You want to have durability. This is something that I think is very much underestimated in the debates. Durability means that we can extend our interest in a particular asset pool or in a particular asset over time. And I will say a few more words about the institutions that provide durability, but it's really durability means that we exclude as many creditors as possible from access to these types of assets, and thereby ensure that the current owners will be able to enjoy the fruit of their investments. Universality means that we extend these rights in space. Universality is a common concept in the law. The Roman law teaches that property is a universal kind of absolute right with effects against anybody. Universality basically means that the rights that have been created, priority, durability, will be enforced against the world, not only between the 2 parties who might have been at the table and bargained over them, but against anybody else as well. And of course, that is true for property rights, for example. That is also true for creating a corporation that will be recognized elsewhere. It is also true for protecting contracts between 2 parties against third parties who might be willing to intervene. And then last but not least, in our world of financial capitalism, convertibility is really important. Convertibility is not just the tradability or assignability of a right, but it's the ability to convert one asset into another one. And it's a way to lock in past gains. So financial assets attain durability by way of convertibility. They have either a legal option to flip an asset into a safer one, or they might benefit from the central banks, for example, offering cash for whatever assets no longer find private buyers. That's how you get convertibility. And you want cash, everybody wants cash, because a state-issued legal tender is the only asset that retains its nominal value, the nominal, not the real, but the nominal value even in times of crisis. Private assets tend not to do that. So here are the legal modules, and this is, I think, really what drove me to write this book. What I found just fascinating is the continuity of the legal institutions that have been used for roughly 4 centuries, perhaps a little more, to code assets as capital. They were founded first in during feudal areas, and property law is the foundation for everything. I'll give you a quote by Bernard Rudden in a second. But here are the core legal, I call them the legal modules, private law institutions that have been used to code capital to this day. We just use different stuff. We start with land, we have firms, we have intellectual property rights, we have financial assets, debt interest and equity interest, and any combination thereof, derivatives, they all use the same legal modules. So property law, collateral law, the common law trust, corporate law and bankruptcy law, and finally contract law. I have included bankruptcy law, which is mandatory law in all jurisdictions that I know of, but bankruptcy law also creates its own priority rules, right? It defines which creditors will have a first bite at the remaining assets of a defaulting debtor, and thereby also creates ranks, priority rules, right? So this is why it's included. Contract law is, of course, typically noted as a bilateral instrument between 2 parties, but as I mentioned before, it will also be protected against interference by third parties. And of course, in our digital age, where we can contract instantaneously with millions, if not billions of people, contract law attains almost universality, because we just enforce the same standardized contract against so many people, so that we don't even need necessarily a property right that is enforced by the state ex ante. So the assets that I discuss in the book, and I devote a chapter to each one of them, that have been coded as capital over centuries, are land, firms, debt, and know-how. These are not the only assets. These are just the ones that I chose. I think there are some of the most relevant ones for the evolution of capitalism. But of course, we also know that nowadays our own behavior and data, what we do currently here on the internet, has become an asset itself, which is also coded as capital through technology, but also through law. So in the book, I start with coding land, the first asset, and the asset that was the most important source of wealth in most countries until roughly the end of the 19th century. I'm using here a picture from Piketty's book, Capital in the 21st Century, and I imposed the little red vertical line that you see around 1880. It really should be 1881. Because what I found so interesting when I read his book is that land, rural land, agricultural land, was the most important source of wealth until roughly the end of the 19th century, and then it no longer was. You can see the kink, how it just drops off. And you can relate this kink directly to legal change. Land was stripped of its durability in 1881 because after a depression in agriculture, legislation was introduced that basically treated the life tenant, pretending not to be a real owner and thereby being able to protect and make durable the estate that belonged to the family. In 1881, this all changed, and the legislation said, the Land Settlement Act and the Land Conveyance Act said, we will treat the life tenant as an owner, and creditors can actually seize land, not the family mentioned without court approval, but we can seize land and reallocate it. Following the enactment of this legislation, over 20% of real estate in England changed hands. So dramatic reallocation of land. And so we still have priority. You have also, to some extent, of course, durability, but this legal change stripped land of some of its durability and helped precipitate the decline of land as the most important source of wealth. you see other assets then rising. And of course, then I was just wondering when I looked at data like this, what happened with these other assets? And as I suggested before, they will just be coded as capital with the same institutions that had been used for land before. So the second chapter is about coding firms or cloning legal persons, as I call it, and I use Lehman Brothers as the example, because what I wanted to show is that the corporate form, which of course has a long history, could trace it to Roman times where it was used not for private, but mostly for public purposes. But the corporate form is no longer just a form that allows us to raise a lot of capital and invest it in the future, but it's being used as an asset minting device by creating hundreds, if not thousands, of subsidiaries under the same holding company and creating financial arrangements between the subsidiaries and outside creditors, but also between the subsidiaries and the parent company, such that the risk of failure lies primarily with the creditors, and any returns that the different subsidiaries make will be funneled back to the shareholders of the holding company, who will be paid out the returns. So when anything fails, they already have received their returns. So you can basically use these asset shielding devices that the corporate law affords to create a money minting machine. And of course, this is exactly what happened in the run-up to the crisis. And these are similar mechanisms that have been used over the last 10 years or so, also for non-financial companies, where you see similar mechanisms being used to create shareholder wealth. For minting debt, I focus primarily on the mortgage-backed securities, and I use a particular structure which I call NC2. This is New Century, a little broker in California, and their houses here, and of course the homeowners get loans. They have to give security, a mortgage. The mortgages will be packaged up, thousands of them sold to Citibank. Citibank creates a trust. One of my other models, you have ownership, you have mortgages, then you have a trust, where all these claims against the homeowners in California are being pooled together and then sliced and diced such that different investors can buy tranches in these trusts and then get the returns from any cash flow that goes into that. Now, what is so interesting about this particular structure is, first of all, that you see already how multi-jurisdictional, if not international, it is. So by doing this, you can take a very immobile asset, land and houses, and make them liquid enough so that investors from around the globe will buy them. The other thing that is interesting about this is, of course, the CDO structure, where we find that when we sell these tranches, the slices and dices in this particular trust, typically investors had at some point problems selling some of the mezzanine tranches, which are not secure enough to get Fannie Mae or even the China Investment Corporation on board, and not risky enough for the hedge funds and other risk-loving investors. And so, in order to place them, the industry came up with a CDO structure where some sponsor creates another corporate venture. Here in the Cayman Island, there was actually a sibling in Delaware, and they raise funds to buy the mezzanine tranches, not only in one trust, but in multiple trusts, and then have rating agencies again rank them again and sell them to different investors. And if you again cannot sell the mezzanine tranches, you just do the whole thing again, and then you get CDOs squared or cubed, depending on how many times you do this. The point here, of course, is looking at the legal structures. So we're so familiar with the financial jargon, special purpose vehicles, and of course derivatives, etc. But what is behind that are property rights contracts, collateral, corporate entities, trusts, contractual claims that are ranked by contract against this particular trust, and of course investors from around the globe, because we also have supported the internationalization of these type of assets. And then the final chapter that talks about specific types of assets or resources that are being coded as capital is devoted to intellectual property rights. And here I used the coding of nature's own code of the DNA. So creating intellectual property rights over DNA. And of course, that is not allowed in principle. There's a fundamental principle in intellectual property rights that algorithms, other laws of nature actually belong to humanity and shall not be privatized. And yet, of course, the temptation situation is great to do so. The Supreme Court in the United States has been pretty liberal, and the Patent Office as well, that if there's any kind of human intervention and manipulation, then that manipulation can, however, be patented. And what happened here is that in 2013, Angelina Jolie, the famous actress, she wrote an op-ed in the New York Times disclosing that she had a double mastectomy because she was carrier of the BRCA breast cancer gene, which can cause devastating breast cancer and ovarian cancer and lead to premature death in women if it's not discovered right away. She also said in this article that she was tested, but that many women will not be able to afford the test because it costs $3,000. Why does it cost $3,000? Other doctors had offered it for a couple of $100 regularly because a small company had been able to come in first in sequencing, not discovering the gene that had been done by scientists, funded by government money from the consortium around the globe, but the sequence that you need to really specify the test that you want to do for breast cancer was done by a small little company in Utah. It used to be small before they got the patent, and they sent cease and desist orders to all kinds of doctors and university hospitals that they can no longer offer their own test kits, but they have to use theirs because they now have this monopoly. Long story short, the Supreme Court struck down most of the patent in 2013, and yet you can see how much money the company was able to make during the 20 years when it had the patent, and then it had created on top of that a monopoly over data and used this data monopoly to make more money in the future from a patent that had been struck down. So let me just say maybe a few words about the conception of law that stands behind this type of analysis. So as most of you, of course, are familiar with, Max Weber, the German jurist and founder of sociology, argued that the modern nation state has centralized the means of coercion. And what I want to stress, however, is that it doesn't follow from that the access to the means of coercion is also centralized. And our institutions of private law grant private parties access to the means of coercion. You can enforce your property rights, you can enforce your contracts, you just have to go to court. If necessary, you can threaten to take somebody to court or to arbitration, which in turn is protected by states committing to enforce arbitral awards. So it's the legal system that institutionalizes who has access to the means of coercion, for what purposes, and at what cost. And how we allocate these access rights really makes a huge difference in terms of what kind of interest will have the backing of our collective means of coercion. So most lay people, of course, associate law with sort of a vertical relationship between the state and its citizens, where the state dictates or prevents or prohibits in criminal or administrative law. Some might also think about a vertical relationship in that constitutional law, for example, can be used to protect civil and political rights against the state. What I'm mostly interested in, however, is sort of this upper left-hand corner where private parties use the law to organize their private affairs with one another. And I think this is, again, a very underestimated type of relationship. Most people talk about free markets and that, the government interferes if it adopts a law. And yet all these markets rely on property rights, on contracts, on corporations, on trusts, etc. They are basically free riding on a social resource, which is the law. So here, just a couple of examples for the kind of institutionalization that the law does in terms of determining who has access to the means of coercion. There are standing rules. Who can have who has the right to bring a case to court at all? In the early enclosure movements in England, many commoners lost their case because the court said that they would enforce only individual rights, not collective interests. And the commoners, of course, had a collective interest. The fact that we allow legal persons to bring a case to court, of course, creates a privilege for these legal persons, not only that they can behave in many ways as if they were natural persons, but they can also use the means of coercion to enforce their interests. What are permissible claims that the legal system will enforce? Property rights, contracts, injuries to person, assets, but there are variations across legal systems. And that's where we have to look to understand who might be able to harness the collective powers of coercion for their own private interests. And then, of course, there are available remedies. Here, I'm just using the classic distinction between property rules, which means I can prevent others from doing certain things or force them maybe even to do certain things, or liability rules, which is basically translating that into monetary types of compensation. There are many more remedies, but depending on the kind of remedies that you might be able to get for different types of injuries, you may or may not bring a case to court. So how we configure all that is really quite fundamental for the distribution of access rights and therefore also the distribution of wealth. Another thing that is often underestimated is the extent to which our understanding of these legal institutions changes over time. Most economists think that property is defined clearly, it should be defined clearly, and then it's allocated, and then the rest is done by markets. But that's not how it works. When you look at the history of property rights, you find that originally they were really use rights, use of a tangible object that you can possess, you can use it, you can alienate it. But over time, with the evolution of the economy, we have used property rights to protect expectations, or even just the probability of realizing expectations in the future. And you can see this basically when you look at the different assets that have obtained property rights type of protections. Land is a classic tangible object, but I showed you already in the example of the securitized mortgages that you can flip interest in land into highly mobile financial assets. Second, going concerns. So a business that is already a running business where owners have expectations of future returns has received property rights protection in the sense that you can get expropriation damages if the state enacts laws or engages in behavior that damages this kind of expectations. Not in every jurisdiction in the same way, but since the late 19th century, you can see case law emerging in most of the advanced economies in that direction. And as I already mentioned, financial assets, fickle expectations about future returns, actually contractual interest, have received similar types of property rights protection. So the law morphs, and it's also an important thing to keep in mind when people talk about the rules of the game. That's the law very often, formal rules of the game. Douglas North taught us this. And yet the players who play the game change the rules as they play. It's not just an independent umpire, they're changing the rules as they play. Okay, here's the quote by Bernard Rudden that I wanted to give you. Bernard Rudden taught legal history and also Soviet law at Oxford for many years. He died in 2015. But I found an article of his from 1994 where he basically gives you the message of my book. And this is what it is. He says the traditional concepts of the common law of property were created I have to move my thing, were created for and by the ruling classes at a time when the bulk of their capital was land. Nowadays, the great wealth lies in stocks, shares, bonds, and the like, and it's not just movable, but mobile, crossing oceans at the touch of a keypad in the search for a fiscal utopia. And now it comes. In terms of legal theory and technique, however, there has been a profound, if little discussed, evolution by which the concepts originally devised for real property have been detached from their original object only to survive and flourish as a means of handling abstract value. The feudal calculus lives and breathes, but its habitat is wealth, not land. And I think that's basically the message that I built on and develop in this book. So a couple of more things, and I said some of this already. So law is malleable. I mentioned this already. We reinterpret this. We change it not only through explicit change case law or legislation, but reinterpreting what it means. There is some institutionalists like Kathleen Thielen have developed some of the language for this. There's drift, there's conversion, but we know this as lawyers. It's an analogy, gap filling, and sort of applying abstract principles of the law to different cases, and then the law changes. We also have greatly expanded private access to the means of coercion because we give private people the possibility to pick the laws and courts and enforcement agencies from different jurisdictions if they choose to do so, because most countries have made their choice of law provisions more accessible. So if you can pick and choose from different jurisdictions the legal features that best suit the needs of your clients as a lawyer, or the client can benefit from this picking and choosing, then you can opt out of legal systems, opt in into different ones. And that enhances your probability of being able to use the coercive powers of some state. Doesn't have to be the state where you engage in the activities, to make sure that that you can ultimately enforce and then maintain the kind of durability, universality that you want to obtain. And who is doing all that? So here I just gave you actually the picture of the Italian translation of my book because it graphically suggests sort of what's going on here. I'm basically saying the lawyers are the masters of the code. So the transactional lawyers are the masters, not of capital, of the coding of capital, of the code, of the legal code. They have knowledge of the law. They must master the law's malleability. They must know how to be able to translate economic interests into legal categories, but also to repurpose legal categories for economic and private interests. They must be very creative. They're very well paid, as many of you know, and they must be persuasive both to vis-a-vis their own clients, and of course vis-a-vis regulators and tax authorities and others with whom they're very often in constant dialogue. And they must have a relatively elastic ethic, because of course there are ethical concerns that arise here when you use the law of one jurisdiction and you bend and push it a little bit. And so you have to, if you want to be creative, you don't want to be too rigid on your ethics. So just a couple of more comments here. One is on globalization, and then I come to my concluding comments here. So everybody knows that we are living in a global financial world, and most associate this with some of the global financial centers. I should have put up Hong Kong here, but I think the leading financial centers are still New York and London. The point I want to make is that these are also centers for coding capital. So the biggest law firms in the world have not only offices there, but they typically originate from one of these cities. So I just checked again sort of the list of the top global law firms. And when you just go down the list, this is basically by equity that or the revenue per equity partner in these firms, but you can use different measures. What you will find is that most of the biggest law firms are either American or English, and they have global means that you have offices in at least 2 jurisdictions. Only if you do a head count ranking of the global law firms do you get a couple of Chinese firms that are in the top 10 or 20 here. But it's basically, when we look closer at what globalization really means, it means the globalization of Anglo-Saxon legal practices. There are foundations for that. I will skip that. Of course, there, every step along the way that's very often ignored, I think, in parlance about globalization. This is not a free space. This is a deeply constructed space, because you also have to think about roles of the legal profession, the organization of the legal profession, the scope of their legal practices, the extraterritoriality of domestic law. All that feeds into the construction of global relations, and that's what the lawyers do. This is also why they're so highly paid, because it's not that easy. So let me just leave you with a couple of concluding thoughts, and then we'll open it up for questions and answers. So the main message of this book, again, is capital is coded in law. It takes a legal system, and ideally from the perspective of capital, 2 or more to code capital. So arbitraging multiple legal system is one of the major powers that capital has. And you can see this also in the evolution of American law, where a lot of picking and choosing of legal system had been going on prior to globalization, because in the US, the jurisdiction for contract law, property law, corporate law lies within the states. So lawyers learned very early on to use the diversity of different rules in the United States for arbitrage purposes. So it's the law that's really the foundation of capital. You can't do it without. Of course, you can have some exchange, some spot transactions in local localities, but if you want to scale markets to national scale or global scale, you need some kind of enforcement mechanism, and that is afforded by the authority of coercion. The second point is that legal adaptation and change is, of course, a prerequisite for a dynamic economy based on private initiative. To some extent, this is inevitable because you don't want to have fixed rules. Contrary to what economists want, you don't want to have clearly allocated property rights. You want to have, of course, those who want to benefit, they will always use this argument, but you want to have the ability to expand on what property rights are so you can adapt it to different types of assets. That's how you make money, not by rigid rules. And then, but of course, there's a fundamental tension also between sort of the adaptability, malleability, flexibility of legal institutions that are based on the expectations that you can enforce rights on the one hand, and the quest for many people around this world to engage in democratic self-governance. So if everybody was able to pick and choose the rules by which she or he wishes to be governed, we wouldn't be able to have legal systems that have any coherence, any meaning for a community. The question is for what purposes and how much we allow picking and choosing, and who can bring different foreign law in or can opt into foreign law and still be here. That's sort of the fundamental normative decisions that societies make. And I think we have swept them under the carpet and in the name of efficiency have allowed some with the best resources in terms of lawyering to pick and choose, whereas everybody else gets stuck with the local rules where they are physically located. So in that sense, I think we have given capital the primacy, and for several decades, that's part of the globalization, the opening up of borders, the opening of free capital flows. It all has gone hand in hand with allowing certain interests to pick and choose the law by which they wish to be governed. And at risk, of course, the ability to self-govern through law. That's what democracies still do. They use also the law to self-govern. They don't have a different device quite yet. So let me leave it at here, and I will stop sharing so I can we can talk.
Thank you, Katharina. My head was spinning as you were talking about the book. I have a lot to ask you, but before I open the floor for questions, let me invite our brilliant discussant, Jet, to give his comments.
Okay, great. Well, I want to thank Angela for inviting me to comment on the book, which I think has rightly gotten quite a bit of global attention over the last few years, both for its insights, but also its accessibility to a wider audience. And I think it shows sort of her versatility as a scholar in the different things that she sort of connects in the book. I should note that I first read her quite some time ago as a law and development scholar, or sort of early writing. Some people may not be aware that along with her unusual background for a US academic, having done most of her education in Germany, she had some early writings on China. And some of her early education focusing on Soviet and Chinese law is something I discovered as a law student quite some time ago. So there's so many things that are interesting in the book that I want to touch on. I'm going to try to restrain myself to sort of four. The first is, and some of these we'll build on, just how much of this is a common law story. Okay, so I think one of the great things about the book is that it does sort of help solve in a bit Weber's England problem, as you discuss the fact that, Weber thought that the civil law predictability, this type of sort of rationalization, his formal rationality, was what's going to allow capitalism to develop, but England industrializes first, right? And I think the story you tell of facilitation and private ordering is a great sort of contribution there. Also here at HKU, I teach equity and trust. I teach the Lehman Brothers case. I teach Citibank. I tell my students at the beginning of the course, they're going to have to hear some things about derivatives and tranches and sort of see how these things work. And I think there's a way in which trusts run throughout the book, right? And trusts, as our UK colleagues are much more apt to emphasize, is this great sort of genius of the common law. Ironically, it's a minor course in the US, right? It's not even a mandatory course, but it's central in most common law jurisdictions. So the way in which I see the answer there being yes, sort of is the fact that equity, right? And it's something that isn't discussed as much in the book, but this particular area of law that sort of developed historically alongside the common law in the US, and equity as a sort of embodying non-legal principles, has a lot to do actually with how trust law sort of got weaved into these different areas and sort of repurposed, because the idea of settler intent as this sort of something that needed to be validated in the interpretation of trust really was, in the 20th century, was exploited to sort of spread its influence and flexibility in other types of areas. And so I think, even there are things going on in the US today that are still very much a part of the story. South Dakota is a new sort of international center for global capital investments because, or just a holding of capital, because there's been local state level reforms to its trust in ways that sort of many people claim to still be innovative. The no part of that is, you mentioned in the book many times the contrast with the civil law and how it sort of thinks about sort of private ordering and innovation. And I wonder what you think, if there really is an argument to be made that there is sort of civil law resistance to these types of forms, and particularly thinking about the trust, right? The trust has gone global. There's a Hague Convention. Everyone, or at least someone in every country wants one. There's attempts to simulate it in almost every civil law country. And it seems that there's enough sort of, interest in this, right? That you can find things that sort of simulate this to an extent that the old common law, civil law sort of distinction doesn't quite hold up. And I don't know if you still folks are as confident about that distinction. The next 2 points have to do with sort of claims that are now centered around the law and political economy movement in the US, which I think has taken up some of the concerns that are expressed in the book. And one of the claims of the law and political economy movement is that the public-private distinction in law is relatively meaningless, or at least obscuring. And I see in the book, you try to finesse this a number of times, right? And emphasize, that they're still analytically useful to focus on the sort of this private ordering. And so I wanted to sort of thought if whether or not the private-public distinction could be looked at in a more sort of traditional sociological lens in the dynamics that you're talking about. A lot of the books, right, you say Anglo-American several times, but a lot of this is American lawyers, right? And one of the things about American lawyers is that they have a lot of self-regulatory control over themselves, right? If you take a legal ethics class, in the US, there's a lot of sort of self-congratulatory rhetoric about the self-regulatory powers of American lawyers being pro-social, right? And most legal ethics classes, they don't talk about things like markets, okay? And you mentioned some things in the book about legal education, and I wonder, if you, in the context of sort of the market for legal services for American lawyers, whether there's anything that really can be done in that particular context. That's sort of like a side note. But the main thing is this issue of sociality, where the private and public blur, not in sort of distinctions about law, but just in the life of lawyers, right? So this common sort of metaphor of the revolving door, right? The movement in the common law, right, between public and private practice in the same types of areas happens both domestically and internationally. Like Dieselet and Garth, their work sort of shows how the international replicates some of these American dynamics, where because public regulators have discretion and how they enforce their particular powers, the fact that there is this movement between the private and the public spheres of practice both fuels their experience as engineers, right, but also sets some of their expectations. And so when we go global, some of the sociality tends to matter because you have some American firms potentially, buying German firms or, penetrating particular markets. But it asks this question, is there an international sort of legal elite sort of influenced by the American model that provides enough of this type of engineering for the globe, right? There's this sort of particular place that generates this type of private public blurring that creates a template that then, produces, specifically through LLM programs, enough sort of engineers for the world in that sense. So in thinking about, the private public split in this type of context and the lawyers who are doing the coding, whether or not, a sociological understanding of their sort of production is important for understanding how this works in practice. The second law and political economy point is this focus, and a lot of the work in antitrust and other areas looking at pre-distribution or pre-market, right? The traditional welfare state tax and transfer model has been questioned by a lot of people. And in the book, the one thing that I was sort of currently curious about was, as someone who works on labor, was the place of labor in that, right? Labor is one of those major pre-distributive regulatory or institutional design issues. So you mentioned at the beginning sort of the freelancer who realizes they can use legal tools, right, to like reduce their tax rate by converting their income into capital gains. And there was a lot of 1990s techno-utopianism about freelancing that sort of wrote on this, but after that it sort of disappears in the book, right? And this is a highly engineered relation, right? There's a lot of your sort of influence of Polanyi in the book, and the commodification of labor, right? And the creation of employment contracts as a way of regulating seems to fit exactly this type of model, right? Because this is where power distribution, right, over productive surplus happens, and the residual prerogative that's given to employers, right? Employment law contracts or the ultimate incomplete contracts really seem to be one of these like core areas that shifts over time. Right, labor crosscuts. You talk about bankruptcy, right? There's a reason why labor is very low, right, in prioritization workers when corporations go bankrupt. So I just had your thoughts about whether or not you mentioned slavery. Obviously, there's a large historical story there. There's a lot about in modern sort of like gig workers, and others about just using sort of re-engineering legal relations in this way. And I think one thing that I sort of admit from my questions, but there's even a context in which like citizenship itself gets coded through migration. Individuals, right, who move labor between countries, whether it's in the Marshall Islands or in Hong Kong, their residency rights, these types of things are also been taken up in this way in which their citizenship gets coded in particular types of ways. The fourth thing here, and I think this is what sort of on a lot of people's mind, is the issue of China or Asia more generally, right? In a book that's as synthetic and ambitious as this, you can't customize this for all the different parts of the world. But I think China presents an interesting way of thinking through some things because, right, it traditionally has a lot of civil law influences, right, like many Asian jurisdictions that follow some of the civil law characteristics that you note in the book that traditionally restrain some of these dynamics. But at the same time, there's been a massive economic integration, right, between China and the rest of the world. A lot of sort of creative sort of legal engineering sort of went into that process as China reformed itself and had to find itself, drawing on and producing itself all these new forms of coded capital. And it's an interesting case studies because it also raises the question of like, the number of LLMs, right? Chinese LLMs in the US and in the UK are quite high. And whether, again, the US has produced enough of these, right, that you don't actually need to reform legal education or things in a particular country, even one as large as China, if you can have a particular sort of grouping in this international elite that are produced in particular metropoles and then exported, right? Greg Schaefer and Henry Gao have an interesting paper about, there was one area of WTO dispute resolution where China invested very particularly so that it could win there, but otherwise you haven't seen all of the sort of 1990s sort of euphoria about adopting American pedagogical methods and things like that really last because there isn't so much of an actual demand. One thing that I think is particularly interesting, today we have this rhetoric around common prosperity and there's this an idea that China is going to develop some sort of different model, but it's hard to see what the fundamental logic of that is going to be, right? It's still going to be organized in many of the ways that you identify as a capitalist economy, but it needs to act out in very sort of socialist ways. And one of the interesting precursors that touches on trust law again here came up with this discussion recently of Huawei and whether Huawei was a state agent under sort of international trade regimes. Now, in some of my own early work, I had noticed that there was a trust structure in the US called an ESOP, an employee stock ownership plan, which was an attempt, in the mid-20th century to transfer shares of ownership from private owners to the workers, right? And one of the sort of stories of that is how that got cut up in a way in which workers actually, they technically owned their shares as beneficiaries of the trust, but had no rights, right, to the management of the company itself. And this is similar to sort of the cutting up of non-voting shares, right? And then sort of splitting that up and sort of a bundle of sticks metaphor for corporate shares. But what I discovered is in the 90s, right, there was a similar, from sort of a different direction, a trend in China, where all of a sudden there was this promotion of employee-owned corporations. For similar types of reasons of trying to find something in between capitalism and socialism. And Huawei sort of got onto this early on. And so if you actually look at the structure of Huawei, what happens is the same type of dynamics where technically in some sense, the workers own shares, but through contract, the founder, Ren Jiefeng, actually retains great veto powers over a wide range of governance areas. The shares that are supposedly owned by the workers are held, right, by the state union. And they, through the sort of creative legal engineering, have created a contractual rights to profits, very sort of discretionary though by management, for the workers, right? So you have and so in some ways they've simulated the trust, right, in the structure of Huawei, the same way that ESOPs in the United States trust this. And I've been trying to find some more details about who actually put these together in a sense, but it seems that this type of method, right, of recoding is very active in one of these dynamic sectors. And there's actually a number of other companies that have adopted this particular model. So I think that the China example is especially interesting to think about, because one of the things that comes up at the end of the book is you have your suggestions for potential reform. And it made me think, and this goes back to the old law and development type of mentality, is like, is there an actual model here? A lot of the things that you're arguing for are basically old restrictions, right? Numerous clauses, bring this type of sort of idea back. Private ordering not so easily sanctioned by the state. And in some ways, I'm thinking about the things that China's been doing recently. This is sort of like what China's doing, but with democracy, right? Is that sort of it seems like some of the things, these sort of interventions that you're talking about are things that are being posited in China, but no sort of democratic country has been able to get their act together to do it. And the other part of the sort of solution side that I was curious about is the constitutional side. A lot of these things are embedded in the constitutional, especially in the United States, imagination and understanding of restrictions on these types of reforms, right? You may be able to sort of like remove American lawyers' self-regulatory powers, as they've done in the UK or other places. You may be able to ban the revolving door, right? But if you want to do something like ban trusts or decommodify things, I think you're going to run into constitutional types of challenges. I think following Henry George, one of my political economy influences, the Netherlands recently like banned areas where you just where you can't own a residency or buy a property unless you're going to live in it, trying to, and in some ways, to sort of halfway decommodify types of things, right? And every time I see type of these more aggressive solutions, I think about what the constitutional sort of pushback, right? These are things that at some level are so deeply embedded in a particular constitutional discourse that it doesn't allow, right, for these types of pushbacks to happen. I guess that's another type of constitutional coding, we could say. So that's there's a lot of more things that came up as I was reading it, but these are just a few of the things that were provoked again by this wide-ranging and fascinating books, and I hope most of my students in the audience can appreciate some of the connections to the things that we talk about as well. So thank you.
Thank you, Jack, for the brilliant comments. And I wonder whether, Katharina, would you like to respond?
I'll leave that to you. I mean, if there are lots of questions in the chat already, then I'm happy to wait and respond to all of them, or I can respond for a few minutes.
Yeah, you can respond for a few minutes first.
Okay, so these are really, really important comments, and actually also quite some new ones as we discussed earlier. So just on the common law, civil law, I think it is very much a common law story in the sense that I argue also in the book that the common law just has always given more possibilities to lawyers to change the system. It also is, of course, an aspect reflected in the structure of the courts. You recruit judges from the practicing bar rather than sending them onto the bench right after law school with special training programs for judges, as the civil law systems do. So it is a common law story, but it's a different one than the classic legal origin story a la Schleifer, la Porter et al. In the sense that I'm saying you have to look at the organization of the legal profession and the courts, and that's really where the action is. Labor, it's a good point. Of course, labor and capital belong together in many ways. I think the story I wanted to tell here is that you can code capital even without labor. So get away from the Marxist connection that capitalism is all about extracting surplus from labor. I think surplus is being extracted, but it can be also extracted from the rest of society via central banks. And of course, there's labor productivity somewhere as well, but it's more indirect. But there is, of course, at every step along the way, you can also look at the recoding of labor relations. It goes really in lockstep. China is a great example. I think it's absolutely right that many of the coding strategies that have been developed in the West have been imported into China, mostly I think through LLM students and other JD students who come to the US or England and learn this there, and of course via Hong Kong as well. So these were the big I think, influencers in that sense. So I think China also has been rather eclectic after the 1980s in putting its legal system back together, building on some of the civil law foundations, but then also plugging common law institutions on top of them, which of course then raises the question, what is really the fundamental difference? I think the lines have been blurred, but I think there's still something in terms of the policing of the boundaries between contract law and property, is how Giuseppe Dari Mattiacci put it, that the civil law still does more rigorously than the common law has ever done, arguably. That of course relates also to the question between of the distinction between public and private law. I think the distinction is actually quite important. It's also rhetorically important. Maybe not, depending on how you look at it, just stepping back, it's not so important, but rhetorically saying free markets, property rights are not up for grabs. These are basically the foundations that nobody wants to touch. I think it plays a huge role, I think, in the way we configure the legal system, if only by not looking into private law matters when we reform and respond to financial crisis. We always regulate publicly, but we don't touch the private law, which just runs apace underneath that. And then lastly, on the Constitution, yes, you're right. We're sort of bound in a system where by having created these private rights, we have created the foundations for capitalism to flourish. And you can't, within that system, easily get out of it. You're being caught up in a system where those with the right resources will use the law against any attempt to reform the system. And I think that poses fundamental challenges as we look towards climate change and thinking about how to rectify some of the problems that we're having, because the system, I think, is really difficult, if not impossible, to change from within. Thank you.
Thanks, Katharina, for a very brilliant feedback. I think this book, even though it was published in 2019, it was actually very timely in the Chinese context. And some of my reaction does resonate with Jack just mentioned. There's a lot going on in China very recently, and there was one major theme behind all these regulatory interventions in China, and that involves capital. There has been consistent, repeated emphasis on warning the over-expansion of capital in China. That capital is, capital is driving companies to engage in excessively risky activities. Look at those fintech businesses like and which is the reason why the Chinese government shut it down, because it was concerned that this might drive into something like Lehman. And overexpansion of capital is driving excessive competition in the Chinese education, which is the reason why the Chinese Communist Party shut down the private tutoring business in China overnight. And overexpansion of capital is why why we have this crazy fan culture. And in entertainment industry, and which is now we are tightening crackdown on celebrities who are avoiding tax. And so seriously, for the past couple of months, I was mostly focused on one thing. I mean, what is the scene of capital that is causing the Chinese Communist Party so worry and concern? And I think I found part of the answers in this book. But in the Chinese context, there's way more nuances because the government is so powerful that it's much easier for public intervention into private sphere, including private law and property law. So that's why we observe such drastic changes very recently. But I think this book will appeal to a very large audience in China who, similar to me, is struggling to understand, what is the problem with capital and why there was such a big concern behind the government's worry about this. And now we have a couple of questions from our audience, and if I may read out the first question from Mr. Kirkwood. When I hear about the coding of capital, I think of coding into the blockchain. Have you considered how blockchain technologies will affect the coding process? I believe one of the chapters of your book did talk a little bit about digital and data. So yeah, would you like to respond to that?
Yes. So of course, this is a rapidly evolving field, but I do have a chapter 8, that asks the question whether there is a new code and whether this code might be the digital and whether the digital code might replace the legal code. In the book, which I really finished writing in late 2018, so that's quite a while ago when you think about technology, I make the prediction that the legacy institutions, the legal code, will encode the digital code rather than the other way around, although I'm not so sure about this anymore. So I think when you think about making a credible commitment and making them enforceable in the future, which is basically what the law and the authority of the law, the coercive means, are doing, some of that can be done by smart contracts and self-enforcement. And yet, of course, we are living in a real world that is fundamentally uncertain, which is also why many coders are now building in, oracles or other ways in which sort of you can catch up with the real world around you once in a while. So there are exit options from the digital code because you can't ex ante code everything. And as long as we have that, and you don't get with AI a system that basically corrects for that itself, I think you still have the human factor, and with the human factor, you probably have the legal factor. But I think it's really an aspect that we have to watch very carefully. It's rapidly evolving, and I think there are many different options for coding things, but the direction it goes, I think, is concerning for us who are concerned with individual and collective freedom.
Right, I see. Well, a second question from Jones asks about, is the threat to democratic governance by capital and its coders you characterize as risk in your last slide? Did that go beyond the level of risk? If we look at the legislative process in the United States today, where the actual legislation is written for the most part by corporate lobbyists in giant law firms, and then pass on into legislation by complacent Congress people who themselves are beholden to corporate donors for their own election campaigns. Any thoughts you think that could be changed? That would be greatly appreciated.
No, I think you're hitting on a really important point. I think these two things go together. I think that it started really with the coding of capital, the building of private wealth. But once you have these resources, you can, of course, influence the political process precisely through the mechanisms that you have described. And so and many legislatures just don't understand the complexity of the system that has been created anymore. Many judges don't understand it anymore. And so that's why you also get the outsourcing as a rationale, not only a power gain for outsourcing. And of course, you're handing over the game to those who want to play it in their own favor. So I think this is, how to get out of that. That's, again, enormously difficult, because in the same way in which we can redefine and repurpose private law institutions, we can redefine and repurpose public law and constitutional institutions to block any change against that. And I think that's why also this system in this country and in others as well has been becoming increasingly ungovernable, because we're just fighting with certain interpretations of what the law is and where the authority of the law is. Any attempt to find a cohesive understanding, a new kind of social contract to move society forwards and deal with challenges as they come about. But you're absolutely right. The two things come together and belong together. And how to quantify which one is more important today, I don't know. But I would sort of emphasize Jed's point again, that for the global world, the coding is how it works, right? Mostly. And then we get on top of that, of course, bilateral investment treaties. We get lobbying, of course, in Brussels and in Hong Kong and China and elsewhere as well. But it's the secondary step that follows from the first, I would argue.
Right. We have time for one last question from Yiming. I'm wondering what the role the civil society plays or can play in this picture. Drawn from my own experience, there are voices against the big tech, and these players do have some influences on the lawmaking process. Another prospect may be the conflicts between the state and big companies, and their opinions stating that China's recent regulation of big tech reflects such conflict. Could you please explain quickly the role played by the civil society and the state?
Yeah, so I think the civil society is really important because it's of course, if we think we the people make this constitution, make these laws, then we the people also should be able to be at the bargaining table when we redefine them. And I think we continually have to push that. That's the only option really one has in sort of making sure that the interests of the general public are being reflected. I'm still a little bit skeptical because again, because of the complexity and the details of the legal system that you have to know to deal with that. But having said that, I think, from the civil rights movement to many other aspects today, savvy lawyers have also been able to uncode some of the coding that has been done on the other side. So I think I'm still fairly optimistic. I also have two colleagues who went to the Biden administration are working on antitrust to deal with big tech, Lina Khan and Tim Wu, as you know. And so they are trying to basically extract what the Sherman Act of 1890 was all about. It was about market structure, not consumer welfare. And if we extract these basic ideas and give them legitimacy, and that's where civil society is in sort of reinforcing that these are the ideas that we really wanted. They are in the law, that we should enforce the law in this fashion, we might make some headways. So yes, I think it's important, but it's not easy.
Well, we still have time for one last question. We have 1 minute left. Professor, you mentioned free riding of corporations within society relying on and utilizing the existing legal system. Doesn't taxation solve the free riding problem? Any comments on tax in general? Because it does seem to be a very important point.
Yeah, taxes is really important, and it's sort of understated in the book. So one thing is that in the global world, tax can't redistribute, right? Corporations can come from anywhere or locate and do business anywhere, and just one taxing power can't do this. So we have new principles of international taxation coming out and being negotiated. I think this will be critical to give tax a little bit more. But I think if there's one thing that the legal coders have learned from the get-go is how to avoid taxes. And I think much of the coding is all about that. And we just have to take that into account when we think about using tax as a simple tool. It's not that easy again.
Fantastic. Thanks, Katharina, for joining us for a full hour. We are exactly on time. And I really like the super efficient and really brilliant exchange among all of us. And thank you very much again. And thank you, Jack, for commenting. And thank all the audience for participating. I will see you guys next time.
Thank you so much, Angela. Thanks, Jet. It was a pleasure. Thanks, everyone.
Thank you. Thanks. Bye-bye.